This is the second of our online in-depths, and the idea of those, in contrast to the speakeasies, which are tend to be a conversation with one person, these are a panel discussion on a particularly thorny free speech issue. And the last one looked at the online safety bill. And tonight we're going to ask whether the warnings that were sounded by quite a lot of free speech campaigners when the Equality Act of 2010 was enacted, we're going to ask whether those warnings proved to be correct. Did they actually, have they manifested themselves in the way that people expected? What is it nowadays that means that more people are criticising the Equality Act, something that sounds like quite a difficult thing to do, and certainly something that might not make you the most popular person in the office, but there are some really serious challenges being posed to the Act. So in a moment, I'm going to hand over to Dr Anna Loutfi, who's a very good friend of the FSU, and she will be chairing the first part of the discussion because she's far better qualified than I am to delve into legal questions. So I'm very relieved that Anna's here. And then we'll come out to the audience after about 45 minutes, and we will finish by 8 o'clock. So Anna is a practicing barrister at Clerks Green Chambers, where she specialises in employment, inequalities and human rights law, and particularly in freedom of expression cases, and also especially in the higher education sector. She was called to the bar in 2019. Before that, she had gained a PhD in legal history and was a legal researcher and judicial assistant, I think, actually in Hungary, I think you worked for a while, but also more recently at the Dixon Poon Law School at King's College London. And she still hosts the school's podcast, The Verdict, which you can find online. She was part of Harry Miller's legal team in his successful judicial review of the College of Policing Guidance, which happened in 2019. And I think you'll agree that she's therefore very qualified to lightly grill our panel this evening. And the rest of our panel are Dr Wanjiru Njoya, who is a senior lecturer at the University of Exeter Law School. And she has a new book coming out, which you can see beside her in complementary purple. She'll wave now. Her new book is called Economic Freedom and Social Justice, the Classical Ideal of Equality in Context of Racial Diversity. And that came out in November under the Palgrave Studies in Classical Liberalism series. And then we also have Professor James Allan, who we're delighted to have with us. He's joining us from, are you in London, James?
Just got to London, managed to avoid all the tracing garbage, so. Very
good. So James is visiting from Australia, but I think you're Canadian-Australian, if that's got that right. Canadian. And in Queensland, he's Professor of Law at the University of Queensland. And amongst his many books is one called Democracy in Decline, Steps in the Wrong Direction. But he also writes widely for newspapers and weeklies, including The Australian and The Spectator Australia. And then they're joined by Toby Young, General Secretary of the Free Speech Union, who I'm absolutely sure that you all know. And Toby will also be joining the panel this evening. So over to Anna.
Thanks, Jan. Thank you very much for inviting me to chair this event. It's been a really interesting event to prepare for. And I'm very grateful to our guests, our panel guests, for joining us as well to share their expertise and their recent research in this extremely fraught area. As Jan said, it doesn't make you the most popular person in the office to say that you have a problem fundamentally with anti-discrimination and equality law, because anti-discrimination and equality in our language, in our culture, are difficult to describe as anything other than laudable goals, noble aims. What could be wrong with the Equality Act 2010? The clue's in the name, it's about equality. So how do you unpack that? How do you critique it? Especially in a culture like ours, where the law is very often driven by ideological and social imperatives about what is right and what is thinkable and what is acceptable. And the law isn't always independent from those cultural initiatives. And very often the job of lawyers today, especially in human rights, is to try and disentangle what is considered to be culturally acceptable from what is lawful and what is unlawful. Now, the Equality Act 2010, for those of you who are not aware, and there's nothing to be ashamed of, is an enormous achievement of drafting, and passed in 2010. It was the last measure enacted by the Labour government that left office in May of that year. And it came about after years of campaigning and initiatives to unify hundreds, well, at least 100 pieces of anti-discrimination law that existed prior to 2010. So what we see over time, basically from the mid-1960s onwards, is the accruing in the mind of the equality law drafter of something called the protected characteristics. For those of you who don't know, protected characteristics are largely considered to be immutable characteristics on the basis of which you cannot discriminate lawfully against a person. And from the mid-1960s, largely to do with patterns of immigration to this country, we start to see disparate pieces of legislation making it unlawful to prohibit, to discriminate on the grounds of race. By the 70s and 80s, we see a focus on sex, later disability, and then of particular interest for our free speech purposes, we have the protected characteristic of belief, including religious belief, which is protected. And then we have protected characteristics such as gender reassignment, age, sexual orientation, pregnancy and maternity, and marriage and civil partnership. We can't possibly deal with all of those separately or together here, but just so you understand that what was coming into being in the form of different pieces of legislation with different protected characteristics is unified in the Equality Act. It's an enormous piece of legislation, over 200 pages. And what it does is it says, on the basis of these protected characteristics, several types of discrimination are unlawful, and then it defines those. So we have direct discrimination, indirect discrimination, harassment, and victimization. These are the different types of unlawful prohibited acts that the Equality Act is the first of its kind to attempt to define in the language of drafting. And I think it's going to come up later today that one of the problems we have with the Equality Act is the definitions that are used and then have to be applied in the courts or the tribunals. The definitions of discrimination are so unwieldy and broad and open to all sorts of abuses that they may, in fact, encourage forms of discrimination on some level. They may create protected groups that occupy a hierarchy over other protected groups. And ultimately, for our purposes, they may restrict or inhibit speech. And I would just signal at this point the public sector equality duty, which is introduced in section 149 of the Equality Act, which gives the state a new say in how we police equality and anti-discrimination in our workplaces and in our public sector, and even our private sector. So the public sector equality duty places a special duty on public bodies to ensure that the protected characteristics are being properly managed, that everybody's getting along okay, that nobody's offended, and that if someone is offended, swift action can be taken with the full backing of this state legislation. Again, that opens up a whole potential for abuses of power where the state gets to define what is acceptable and what is not. And just to go back to the protected characteristic of belief, whereas initially the drafters of the Equality Act would have seen belief and religious belief and freedom of conscience and thought as something that goes with a democratic pluralist society where diversity of opinion is tolerated. One of the problems that we have with the Equality Act is that the criteria used to assess which beliefs are protected and which not are sometimes skewed in favor of ideological or cultural biases. And the case that probably will come up today with respect to that is Maya Forstarter's case, where initially at the Employment Tribunal, her belief that you cannot change sex was found to be, according to the criteria known as the Granger criteria, unworthy of respect in a democratic society. Thankfully overturned at the Employment Appeal Tribunal. However, the question is, does the protection of belief under the Equality Act 2010 actually preserve pluralism and diversity of opinion, or does it actually have an opposite effect of increasingly contributing to a culture of ideological conformity in our society? And finally, is that the fault of the Equality Act, or is the Equality Act simply a symptom of a culture that we have seen growing over the decades, which our panelists will speak to, I'm sure, whereby consultancies, HR departments, all sorts of policy wonks and think tanks have made it their business to ensure that nobody is offended and everybody is in a safe space, and that anybody who speaks out of line is sanctioned or punished. And I think we need to sort of seriously address how we tackle this kind of cultural trend, and whether we can do anything about it directly with respect to law. Can we amend the Equality Act? How would we do that? What would we do? And my final provocative question to our panel is, maybe we shouldn't bother. Should the Equality Act be scrapped? So with that little bombshell, I'm going to turn over to the first of our panelists, Dr. James Allan, Jim from now on, I think. Could you speak for 3 to 5 minutes on your position, both with respect to the Equality Act and equality law in general?
Yes, I can. But let me first start by thanking the Free Speech Union. I work in Australia in a law school, one of the better law schools, and we don't have a free speech union in Australia. I think I was one of the first to join Toby's, even though I'm Australian. Let me tell you, if you are a right of center law professor in pretty much anywhere in the Anglosphere, there is not much free speech. You have two choices. You either go into the closet and keep your views quiet, or you make them so vocal that you raise the cost of anything happening to you. That's what I've done. And that's because of that, I get quite a lot of sort of conservative law school students and even other students in the university, and even some other academics who come and see me all the time. I don't know what it's like in Britain. My sense is it's worse in Britain than Australia, but there is no free speech in universities unless you're incredibly vocal in public like me and dare them to do something. So far, that's worked for me. At any rate, I'm a constitutional law prof, and I do legal philosophy as well. And I think the Free Speech Union is doing God's work. I have to tell you, over the last 2 years, if it weren't for Toby Young's FSU, as well as his Lockdown Skeptics organization, I think I would have gone insane. That was an absolutely brilliant body. So in my 3 to 5 minutes, let me just firstly give you my sort of core stances and then an idea of where the discussion might go to. So obviously, like most listeners, I'm a pretty huge emphasis on free speech, but let me just be clear, I am not a sort of Jeffersonian natural law type. You get a lot of free speech adherents, a lot of libertarians who think that there are some sort of natural entitlements that we get just because we're human, or they might trace it back to the UN declaration, something like that. I don't actually think you can cash any of those arguments out. I don't think there are these natural entitlements. So that makes me a little bit unusual. I sort of think you need to ground it in a David Hume sort of philosophical sense, which will take you to Jeremy Bentham. And then, I don't know how many people know this, but John Stuart Mill actually was an acolyte of Bentham. He's a utilitarian through and through. And the phenomenal stuff he writes about liberty and free speech is all grounded on it has better consequences. And I think that's what actually convinces people and delivers it. But whatever your core foundational defense of free speech might be, we're all in a big tent here. Let me just say it's under threat for sure. I think Anna covered most of the reasons why. Here's the sort of questions that might come up tonight then based on that sort of premise. Firstly, one interesting issue is, why is equality such a powerful idea today? And it is incredibly powerful, because when you start looking at the idea of equality, there was a very famous article written by an American about 25 years ago called The Empty Idea of Equality. And it is a second order good. I mean, equality is worthless without a first order set of views about why something matters. So all equality tells you to do is to treat like cases alike, but you first have to decide what counts as a like case. So in a really basic sense, nobody complains if you discriminate against a blind person for a job as a pilot, right? Nobody thinks that there's any problem with that at all. And that's because we have a first order view of the kind of things that matter when it comes to being a pilot. Equality is a pretty empty concept. It's and this is a long-standing view. I think Peter Weston wrote it in the Harvard Law Review about 25 years ago. I think one of the reasons equality is such a powerful idea is we have so little moral consensus today with the breakdown of Christianity. This is no novel insight by me. Alistair McIntyre has been talking about this for ages, but basically in the West today, people talk across themselves. The Kantians can't really talk to the egalitarians, can't talk to the utilitarians, can't talk to the humans. I mean, they agree on a few things, but because they differ on first premises, whereas 100 years ago, almost everyone shared a certain sort of Christian worldview. You know, the biggest dissensus you got was that Protestants didn't want to have anything to do with the Catholics and vice versa, where their differences where you could put a piece of paper between them. So that's an interesting question. Another one is why people today are so keen to give so much discretionary power to judges. I've sort of made a career saying, this is a terrible idea. You know, 50 years ago, the lawyerly caste was politically to the right of the median voter by a fair bit. Today, the lawyerly caste in the US, in the UK, and everywhere in the English-speaking world is noticeably to the left of the median voter. And I've always said, when you buy a Bill of Rights or any sort of big ticket piece of legislation, all you are buying are the views of the lawyerly caste. I would not buy those views. In a million years, I would not buy them. So that's another issue. Then you get into the whole problems around group entitlements. And can you cash out group entitlements in a non-arbitrary way? Any group rights claim, can you cash it out in a way that's just not completely arbitrary? I don't think you can. Whether it's the type of job, you know, people always push for some sort of statistical balance when it comes to good jobs, but, you know, women, minorities don't tend to push for statistical equality when it comes to being a garbage man, or they don't, you know, push to be, what is it? Men have something like 95% of the deaths in work. You hardly ever get anyone pushing to have more deaths for women. Or they never go back and they never say, look, you know, homosexuals are grossly overrepresented when it comes to political aids. So maybe, you know, we have to fire a whole bunch of them to get statistical equality. That never happens. Everything is arbitrary on those fronts. You've got problems with how you rectify the past. Here's another issue that we might touch on. Why is it conservative governments never fix these problems? You know, Douglas Murray is great on this stuff. When it comes to appointing people to the sort of tribunals that deal with this, even conservative governments won't appoint conservatives. It's true in Australia, it's true in the US, with the partial exception of Donald Trump, who was pilloried for this, but he actually did appoint some. It just never happens. And they never repeal the legislation that left-wing parties bring in. And when I say never, I mean that literally. Lastly, and then I'll finish, when it comes to Wanjiru, excuse me for not getting your name right, Wanjiru? When it comes to Wanjiru's claim in her book, you know, one of the basis that these arguments work is we need government to step in when there's a market failure. And the problem with that is the people who make those claims have never read Ronald Coase. Now, Ronald Coase, one of the great economists of all time. And it's true that a market failure argument has some oomph to it. But the problem is, and Coase made this clear, if your alternative is government, people who make this argument just assume there's no government failure. And government failure is usually worse than market failure. And so if you're going to run a market failure argument, you should stop people immediately and say, is the supposed solution that involves government, is that going to have a bigger failure rate? Now, if you're like me and I'm moderately skeptical of government, if they get it right half the time, I used to think they're doing a great job. After the last 20 months with the pandemic, I now figure if they get it right once in 100 times, they're doing a pretty good job. But government failure tends to be worse than market failure. So it's not an argument to point to market failure unless you make the Coase point that in this instance, government can do the job better. In my view, that's almost never the case. So those are the kinds of things that might come up. And again, thank you very much for having me.
Thanks very much, Jim. Really fabulously provocative points covering a range of issues. And it's good that you referenced Wanjiru's book, because that gives a nice segue to pass over to Wanjiru Njoya for her 3 to 5 minute statement on the Equality Act and equality law.
Thanks so much, Anna. Thank you to the Free Speech Union for inviting me to this panel. I have really enjoyed hearing your summary of the problem. because I cover all those issues in the book, and I completely agree with the problems, the way you've described them. I will just add a couple more things that I look at in the book. One is to do with the idea of justice and the sort of philosophical debates about justice, because many people say, well, we need some kind of Equality Act because that's how we do social justice. So I question the idea of justice and the sort of link between people's political ideals and what they refer to as justice. The other issue I would raise is, Anna, you asked, this was your bombshell question, should the Equality Act be scrapped or amended? I think I argue in the book that it should be scrapped. And in fact, I think it was in 1992 that Civitas published a paper saying that at the time it was the Race Discrimination Act and the Sex Discrimination Act and a bunch of other acts saying they should be scrapped. So yes, that's what I think should happen. But then there's a strategic question of whether you will get political consensus to scrap this law, the answer being probably no. So the question is, what would be the priorities for amendment? I think you touched on them, this idea of protected characteristics and the public sector equality duty. But I think there's also a more important, and of course, harassment, the problem with harassment being, you know, I feel so unsafe, I feel so harassed. But I think there's a more important issue, and this is what I have found to be the greatest challenge in talking about these issues. People are afraid of what would happen if you didn't have this law. So even when they agree with all the problems you've identified, they're afraid, they're scared of what would happen without such law. They think, yes, it's got many problems, but it's better than nothing. So some of the things people say to me, they say, it would be just like Jim Crow if we didn't have this law, you know, that all the pubs would be putting up signs saying no blacks, and, you know, you wouldn't be able to go anywhere because nobody would have you. It would be just like no one would be able to get a job. People are really afraid that that's what's going to happen. So a lot of, you know, just promoting my work has been trying to reassure people that that's not what would happen. It is fundamentally about how we understand human nature and our fellow human beings. And there are actually many frightened people. Well, you've seen with the whole pandemic, there are many frightened people who are afraid of others and who think that the only reason I have a job is because of the Equality Act. The only reason my neighbors are not attacking me is because of the Equality Act. So there's a fundamental problem there. And this is one thing I talk about in the book, about markets and human interaction and how we can have faith in the idea that if I have a product to offer, people will buy it. And if I have skills on the marketplace, somebody will give me a job. This is the other thing that I try to promote, because I think we can get people to calm down and imagine life without an Equality Act if they're not so afraid of, well, I guess afraid of life generally. One more thing, I haven't mentioned our students, our law students. They get all the teaching about social justice and how important it is to respect everyone, you know, to be inclusive, to be diverse. They never get to hear anything about free speech. I really should inform you of that, because I think many people think free speech, the value of free speech is self-evident. So they think, you know, why wouldn't anybody want to uphold free speech? But you would be surprised that students at university today, at least in law schools, tend to hear nothing at all in any of their courses about the importance of freedom. I find they get surprised when you talk to them about freedom. They've not heard this from any other of their lecturers. So they say, freedom, what, why? They don't understand why. And you have to kind of walk them through why freedom matters, which sounds odd, but that's what we've come to. Justifying freedom and explaining to students why it's important. I'll just give you one example from my classes, because I teach equality law and the Equality Act. And if I ask students, do you have a legal obligation? So not social or cultural or moral, but do you have a legal obligation to choose your friends from a diverse group and not to discriminate against anybody when you're choosing your friends, when you're choosing somebody to date? And they say yes. The Equality Act says that you're not supposed to discriminate. They think it applies because nobody has told them it doesn't. And even after they study the Equality Act, where it doesn't say don't discriminate against your friends, it just seems to fit in with what they hear around them all the time, that this must surely be the law, this must be my obligation. And that worries me. It worries me that we have students coming out of university with an understanding of the law that is inaccurate, but that reflects what they think is what they see around them in society. So when we worry about free speech in universities, I think it's not just about should controversial lecturers have the freedom to speak, but it's also about what we prioritize when we're teaching, and whether we expose our students to ideas about freedom, and whether we explain to them or allow them to learn that freedom is important, because many of them never hear this throughout their entire career at university. And I think that's a problem.
Thank you very much, Wanjiru. I think that if I were to summarize your final points there, which I think are really important for discussion later, is whether the Equality Act, particularly through the public sector equality duty, which puts this duty on public bodies to police culture, if you like, has created this confusion in people's minds between culture and law. And it also promotes a culture of coercion over a culture of individual autonomy and free choice, where freedom of expression gets thrown out with the baby as well. So I think that's a very interesting point, and it's one of the legacies of the Equality Act that we're struggling with today. Toby, what in a nutshell are your problems with the Equality Act 2010? Oh, I think you're muted.
I knew that would happen. Can you hear me now? Yeah.
Yes.
Thank you, Anna, and thanks for agreeing to chair this panel, and thank you, Jim, and thank you, Wanjiru, for being on the panel. And so far, your comments have been great. I wanted to say, just pull back slightly and try and get to the nub, I think, of what the problem with the concept of protected characteristics is. And my objection to protected characteristics is that essentially it is changing the law. The Equality Act, the Equality Act didn't invent, I don't think, the concept of protected characteristic, but it formalised it and put turbo boosters beneath it. And the problem with protected characteristics is that it essentially says people who belong to particular groups, who have certain characteristics associated with discrimination and being a member of a historically marginalised group, that they need stronger legal protections than ordinary people. So it effectively creates this kind of hierarchy in which the law isn't applied equally to everyone, but it protects some people better than it does others. And that seems to me to breach the fundamental principle that everyone should be equal in the eyes of the law, that justice should be blind. In every US court there is a depiction of justice with a blindfold on, and that principle that refers to the fact that justice, in order to be served, has to be blind. The law has to apply equally to everyone, and that is a fundamental principle of the law and the rule of law. To say that some people are entitled to more legal protections than others in virtue of their possession of certain immutable characteristics seems to me to be a breach of that fundamental principle. And the sort of thinking behind the creation of these protected characteristics is that somehow it'll promote social harmony, it'll promote social integration, that if you give to these beleaguered, historically marginalised groups better, stronger legal protections than you do to everyone else, that'll make them feel more included, safer. It'll protect them in a way which levels them up so everyone is equally protected, because if you're not a member of those marginalised groups, you can enjoy you can expect a kind of degree of protection anyway. So it's a kind of levelling up is the sort of concept behind it, and that'll promote social integration, social harmony. But my fear is that if you create a kind of hierarchy of legal protections, and if you create if you enshrine the principle in our laws that some people are more entitled, more deserving of legal protections than others, far from enhancing social harmony and social integration, it will ultimately have the opposite effect. It'll make people who don't have those protected characteristics, who don't think of themselves as members of victim groups, they'll develop a grievance. They'll feel as though they're being treated as second-class citizens, that they're not getting the same protections as other people, and that seems to me to be socially divisive rather than something likely to produce social harmony. So anyway, I'm not a fan of protected characteristics, and for that reason not a fan of the Equality Act. But like, I have to agree with Jim and Wanjiru that the chances of this government, albeit a Conservative one, repealing the Equality Act, I think, are zero. So what can we do? We can perhaps hope to reform it in some ways, and the Free Speech Union has been trying to persuade the government to accept an amendment to the freedom of speech, the Higher Education Freedom of Speech Bill, which is going to strengthen protections for free speech in universities in England. And the amendment we want to make would disapply the Equality Act to intellectual conversations within universities. At the moment, one of the most pernicious ways in which the Equality Act hampers freedom of expression is that Section 26, which is designed to prevent harassment, is interpreted by activists on campus and diversity-crats who work for universities as prohibiting the expression of certain arguments on the understanding that the merely expressing certain points of view constitutes a form of harassment. And the public sector equality duty creates this legal duty on the part of universities, not just universities, but universities as well as other public institutions, not to create intimidating, hostile, degrading, humiliating, or offensive environments for people who have protected characteristics. That's part of that is a legal duty created by the Equality Act 2010. So if someone claims that a gender-critical professor like Kathleen Stock, making certain arguments, setting out her philosophical point of view about trans issues, if a trans student claims, or an ally of a trans rights activist claims that merely allowing her to express that view creates an intimidating, hostile, degrading, humiliating, and an offensive environment as far as they're concerned, that's often invoked as a reason by university authorities for penalising people like Kathleen Stock for articulating those views. So we've been trying to persuade the government to accept an amendment to the Higher Education Freedom of Speech Bill, which would disapply that particular clause of the Equality Act, where members of universities, whether students or academics, are speaking in good faith and trying to contribute to a debate, just having an argument, a discussion, and clearly not intending to harass anyone. But unfortunately, I don't think we're going to get anywhere with that particular amendment. I don't think the government is minded to accept it. I don't think the government wants to open up a battle on that front by doing anything which would appear to be disapplying any aspect of the Equality Act, because they don't want to have that fight at the moment. I don't think that means they never want to have that fight. I think there is some glimmer of hope that the government may in due course hold a consultation about reforming the Equality Act and invite people to submit their views about how they think it should be reformed, and that might be another opportunity to reform it in the way I've described, but in other ways too. But I think that the chances of that happening probably before the next general election are lower than 50%. So I agree with Wanjiru, I agree with Jim, and I think unfortunately the chances of doing much about the Equality Act, even where it's being weaponized in the way it is on campuses to shut down unfashionable speech, I think the chances of succeeding in doing it at the moment are quite slim.
Thanks, Toby. Tour de force, as always. That's a lot of stuff to unpack. So what I'm going to do is try to isolate some points. But if you want to jump in, any of you, at any point to take the conversation somewhere else, please do feel free. So I'm just chairing, I'm not leading. Toby, what I take you to be saying again, and this follows on from what Wanjiru has said, and James, well, Jim, you talked about the discretion that judges have. Which draws our attention to something that Wanjiru was speaking about on the university campus where she works and on the basis of what she teaches, which is that there's this blending of law and culture. It's difficult for us to know where one starts and the other stops. And obviously, Toby's highlighted a main reason why we can't just throw the Equality Act. I mean, it's not just about the intention of government or the willingness of government. It also has to do with the embeddedness of the assumptions of the Act in policies and in all sorts of cultural assumptions about how institutions are run and what's acceptable public behavior and comment. So to throw out the Equality Act is almost like trying to totally reset Western civilization in one full swoop, and it's not a practical option. But if we go back to what Jim was saying about the discretion of judges, could it be that if judges have a responsibility to see that there are genuine issues here in terms of how the Equality Act is being applied, could they not drive a culture change? And I'll just give you an example. Section 26, which Toby Young mentioned, which is the Equality Act prohibition of harassment. You read out the part that dealt with unwanted conduct that leads to a hostile, degrading, humiliating, or offensive environment. But what's important is that it's unwanted conduct related to a protected characteristic. Related to is so wide. It means that the conduct doesn't necessarily have to be seen directly as focused on or attending to the protected characteristic. It can just be perceived as related to a protected characteristic. It's a completely subjective definition of harassment. There is no objective criteria whatever. Can judges, in your opinion, this is really to Jim, but I can throw it open, can judges harness a kind of countercultural power and bring objectivity back into case law in terms of their judgments and their reasoned arguments, so that these legislative principles, which are so subjective and vague, are given legs and are given a rational and fair basis in the case law through proper and responsible judicial assessment that is not frightened of being independent of the culture wars. Is that a question that we can speak to?
I guess that's to me. Well, look, let me answer this in a bit of a roundabout way. I think, one of the things I do is I look at how judges act in the Anglosphere with bills of rights, whether they're statutory bills of rights or constitutional bills of rights, Canada, the US, Britain copied the New Zealand statutory bill of rights. And here's the thing, and this is generalized, I'm happy to cash it out in particulars later if anyone wants, but whenever a right to free speech runs up against an equality right, in overwhelmingly general terms, judges across the Anglosphere will side with the equality right. So Australia has no Bill of Rights at the national level. There's more scope to speak your mind in Australia than there is in my native Canada, which has one of the strongest written constitutional Bill of Rights going, with an incredibly strong right to free speech. But the judges will just, because the judges themselves are they're simpatico with the equality stuff, they will always treat it as a reasonable limit on the right to free speech. And so you are effectively buying the views of the judges. These are good faith views. Let me put it this way. If there was a big ticket Brexit issue and you had the UK Supreme Court, does anyone honestly believe that, when they bring their honest, sincere views to the table, you're going to get a sympathetic outcome if you're a Brexiteer. No, you are not. And it's because they bring to the table a package of views. And it's not, and that is the problem when you package effectively moral entitlements in a regular piece of legislation or in a Bill of Rights or in a constitutional Bill of Rights. You are effectively asking a real life human being to be making calls that involve him or her having to make value judgments. And they will make value judgments. Now, if you had these same issues in the 1930s in the US and their Supreme Court, you would have found that free speech won right down the line. I mean, one of the things I get asked all the time is, why can't we just buy the US First Amendment and the free speech entitlement of the US First Amendment? You know, there's no stronger constitutional protection in the world for speech than the US First Amendment. And you know what? If you had not had all of that case law, you cannot buy that today, because every post-World War II Bill of Rights is not bringing with it the US jurisprudence. Even today in the US, if Hillary Clinton had won in 2016 and appointed the last two Supreme Court judges, US free speech jurisprudence would be watered down as we speak. And so the problem is you can't buy the US First Amendment because you're not buying, 50, 80, 100 years of case law, which is, so the judges used to go through law schools and have it drilled into their head by left-wing organizations like the ACLU, the American Civil Liberties Union, that they would protect anyone. They would protect Nazis when they're marching through a Jewish part of wherever it was in Chicago, or the Jewish part of, I can't remember. Today, the ACLU will not stand up for free speech. They will not do it in the US. All you're relying on the US today are these leftover sort of remnants of pro-free speech case law, and the fact that a few Republican presidents have appointed people to the Supreme Court who will protect. But you know what? It's really hard to do. Even when you're Trump and you have a list, it is very hard to find right of center free speech judges to appoint to the Supreme Court. In Australia, you can barely find anyone. I have friends in Canada on the right who tell me they can't think of a single person they would put on the Canadian Supreme Court who would do that. Not a single lawyer. That's how far the lawyerly caste has moved. And so it is far harder than people think. And I just basically think we need to take these issues as far as possible away from the judiciary.
Yeah,
I would repeal the entire act as well. And I don't know why a government can't do it. They would be immensely popular if they did it.
Yeah, I would agree with that. And it isn't just a kind of general cultural shift which is reflected in the judiciary. It's also because various activist organizations like Stonewall, for instance, are actually paid by the Ministry of Justice to deliver training to the courts and tribunals service, essentially telling them what sort of decisions they should make in complicated cases where they have to adjudicate between protecting free speech and protecting trans people from a perception of harassment because people are making gender critical arguments in their presence. So there's a kind of systematic attempt to make sure that where judges can exercise that kind of discretion, they don't exercise it in favour of free speech. And this, of course, is an important question which is going to come up when considering the question of whether Britain should enshrine yet another Bill of Rights in an Act of Parliament. And there is currently a consultation taking place about whether we should reform the Human Rights Act, and that would be one possible reform. And it would also elevate the Supreme Court of the United Kingdom above the European Court of Justice. At least that's one proposal that has been consulted about. And that sounds good on the face of it. You know, an Act of Parliament creates a new Bill of Rights. One of the first 2 or 3 Bill of Rights is a right to free speech, and it can't be overridden by the European Court because the ultimate chamber will be the Supreme Court. But the difficulty with that, as Jim points out, is that can we really rely on our own Supreme Court justices to always uphold free speech when there is a conflict between the right to free speech and the right to privacy, say, or the right to free speech and the right to live and work in an environment free of any form of harassment? And I don't think we can. The problem with trying to import something like the First Amendment into the UK is that, as Jim says, you can't dictate how judges are going to interpret it, and you can't insist that judges always prioritise free speech, because there are always going to be circumstances in which free speech shouldn't be prioritised. It's never going to be an absolute right which takes priority over every other. No one would defend, child pornography or betraying state secrets or even libel. So there are obviously going to have to be limits. So judges are always going to have room for manoeuvre. They're always going to have to exercise their discretion, particularly when it comes to weighing up the claims of other rights, competing rights. And the problem is that will we actually be better off if we entrust our own Supreme Court as the kind of ultimate arbiter of making those sorts of decisions, rather than the European Court? After all, the European Court, some of the justices to the European Court are appointed by Hungary and Poland, and for all the shortcomings of the governments of those countries, the justices they appoint to the European Court are probably going to be more free speech, more pro-free speech on average than the Supreme Court justices in the UK. So they might actually be, ironically, better guarantors of our free speech than the Supreme Court, following the passing of a Bill of Rights. Anyway, so that I'm not necessarily against trying to pass a Bill of Rights and making our own Supreme Court, giving it supremacy in these areas, but I do think it's tricky. And of course, the other risk of enshrining a Bill of Rights by Act of Parliament and trying to strengthen free speech that way, and coming out of, or at least partially coming out of, the European Convention framework, is that what's to stop another Parliament, perhaps led by, in which the Prime Minister is perhaps Keir Starmer, reforming that Bill of Rights and downgrading the importance of free speech? And if we can't then appeal to the European Court to protect our speech rights, which we can at the moment, over the heads of our elected government, what can we do in that situation? It might be that we're creating a hostage to fortune by ultimately empowering Parliament to define free speech in that way, and relying on Parliament and the Supreme Court to protect it, and giving up that lifeline which we currently have, which is that we can always appeal above the heads of the Supreme Court to the European Court of Justice.
Can I jump in quickly and have a question for Wanjiru? Because I did have the pleasure of reading parts of your new book, which I hope people go out and buy. And if I'm right in my interpretation of your analysis, you would respond to Toby. I mean, we've got rid of the judges, they're hopeless. Okay, fine. But you would have an alternative position, which is that legislation is not the answer. We need less, not more. And also that part of the problem, as you see it, is that the very concept of substantive equality cannot be criticised in our culture at the moment, you say in your book. And I don't know if you think that is really the problem that we have when it comes to equality law, that we can't criticise equality and we solve problems of legislation with more legislation, and then we add to the problem.
I think the reason why, I mean, legislation is always a problem, but the reason why it's a particular problem in this context is if it leaves the Equality Act in place, which is from what Toby said, that's what the free speech law is doing, then you're adding a layer of legislation on top of the Equality Act that's causing all the problems. All the challenges to free speech are caused by people saying, I feel unsafe for my protected characteristics. So if you leave that in place, I don't see what difference it makes if you pile up a huge amount of legislation on top of that. But I think I'm pretty optimistic about the prospects for change, not from the courts or even so much from the legislature, but from the fact that so many people can see the problem. And there's I think, okay, let me give the example of Brexit, because before it happened, people used to say, oh, it's impossible, it'll never happen. You know, don't even think about it. And then it happened. And I think one of the key things in making the kinds of change that we're talking about is when you get a mass of people that can imagine change. And I think one of the problems we have at the moment, so many people feel attached to the idea of equality, even though they know the problem. And just to give one example of how this manifests is in virtue signaling. So people, even the ones who are against the Equality Act, they always begin by saying, oh, I'm in favor of equality, but I think there's a few problems. I don't like discrimination, but so we just become accustomed to virtue signaling in this way, and then expect politicians to feel confident about fighting this law. They never will. No politician wants to feel like they're a nasty person. So I think one way we can create the confidence for the change we want to see, because I do feel confident that many, many people would welcome this sort of change, is by quitting all the virtue signaling and saying we would like to see equality, but just in a different way, in a very paradoxical way. The mere fact that we say, well, we don't want to scrap it, but we'll want to make a few amendments, if anything, causes it to become even deeper entrenched, because that's like we're saying that we agree in principle with the equality law, we just want to see a few tweaks. Well, when that's not even the case, the legislation is poisonous, it's poisoning the culture. And I think if we all had the confidence to say that and to quit the virtue signaling, that would actually help legislators to imagine that they could pass such legislation, because I know at the problem they view it as something that could never be imaginably done, but it can, if we can just see that vision. I'm afraid I don't see how that's possible at all, because it's true that we have had some cases that have given people hope, but I'm afraid that the hope has gone further than those cases actually merit. I have to say that the idea of proportionality is not one that the judges are just saying that proportionality analysis was wrongly applied and not sufficient weight was attached to free speech. And I think that what you're going to see institutions doing is taking greater steps to show that they have attached sufficient weight to free speech in the proportionality analysis. The judges are not saying, I think you should do more to uphold free speech. They are saying, I think you did not do enough in this case to attach sufficient weight to free speech. And I think what we're going to see, especially from universities, is meeting that potential challenge by saying, I've attached all the weight that I could possibly attach and still came out against free speech. I don't share that optimism about the courts, but I do have a lot of optimism in some kind of grassroots, groundswelling defense of free speech.
The High Court decision in the Miller case was pretty pro-free speech. It didn't go as far as Harry Miller would have liked, because the judge in that case, Justice Knowles, whilst he said that it was wrong of Humberside Police to have investigated Harry in the manner in which they did, he didn't go further and criticised the College of Policing's hate crime operational guidance, which was the guidance Humberside Police were following when they investigated Harry and recorded what he'd done as a non-crime hate incident against his name. And the Court of Appeal went a little bit further, and that too was encouraging, but they didn't go very far. But I think there is some hope, and the further you go up in the judiciary, the less woke the judges become, and you see that in the Harry Miller case. You know, the Court of Appeal was marginally less woke than the High Court, and neither were particularly woke. So I think there is perhaps some grounds for hope, but we can't leave it very long, because as the non-woke, rather elderly Supreme Court justices are replaced by kind of younger, woker justices, then it's going to be harder and harder.
There are two constitutional structures that have stood this test of time. the British parliamentary sovereignty system, which I think is the best ever, but equally good almost is the American separation of powers. When you try to have halfway houses, they don't work. So one of the terrible, well, many terrible aspects of the Blairite undermining of the British Constitution was this sort of statutory Bill of Rights, which sort of tries to give you an American type uber powerful judiciary. Now, I think it was the David Cameron government that then brought in, and this is only true of Britain, the government does not pick the judges here. This is astounding, right? So in Australia or Canada, the elected government just picks the judges they want. You can have an American system where you put them through an upper house review by the Senate. In Britain, you have a judicial appointments commission. Now, there's like 15 people, 7 of whom are top judges and members of the bar, the president of the bar. Now, there are 8 laymen. If anybody in the planet thinks that 8 laymen are going to stand up to the Lord Chief Justice, the master of the rolls, the president of the bar, when they pick the next judge, you're just insane. So effectively, Britain has a system where the judicial caste is choosing their own replacements. This is insane. You are not going to get another Lord Sumption. The first thing you should do is repeal the judicial appointments commissions. This is an act of it's a terrible statute, and it allows the judicial appointments to be made by other judges and the lawyerly caste. So you can't pick a sort of a Richard Posner come in. He was branded by the American Bar Association as unappointable. Richard Posner. So if you wanted to bring in a heretic like pro-free speech guy, you would not get him through, Toby. He would not get through the judicial appointments process, right? And so the idea that we can, minusculely go through the case law and point to a few things here and there that we like, well, we've all done that, and I'm sure that's true. But in big picture terms, we have much more hope working through the political process and sort of putting some pressure on a Tory government to actually get rid of these statutes. I'm not totally negative about getting rid of these statutes, but you have to raise the cost. So it looks like they're going to lose an election. And until you do that, forget it.
Right, over to Anna. Do you want to oversee the final bit?
Yeah, sure. Thanks, Jan. And thank you, everybody who's attended. The very interesting questions and thoughtful and provoking. I suppose, given the time that we have, it just befalls me to say to the panel guests, thank you very much. But also, could you maybe say in a minute or so how you'd like to leave this conversation in terms of thinking forward about strategic steps with respect to this kind of legislation? What should we be focusing on? What should we not be focusing on? I'll start with Jim.
I just think people need to be braver. One of the studies that Cass Sunstein did in the US looked at people who've been accused of things like racism when they don't think they've done it. And your instinctive response is to apologize. And when they play this out with groups, they treat you worse after you've apologized. It is never a good idea to apologize. If you don't think you've done something wrong, never, ever apologize. And you know what? That has far better consequences. So stand up to people. Don't, there's a tendency to want to be polite and be nice and just do the deferential apology. And then they come after you more. I know Toby can speak to this firsthand. It is an error. And so, stand up to them and turn the table on them. Often, they will back down, especially with group. There's a lot of people out there who agree with us. And at the first sign of someone standing up, they will jump on board. That's what I recommend. And thank you again to the Free Speech Union. Go out and, proselytize to your friends.
Thank you, Jim. Wanjiru, what would you like to add to that?
I agree. Quit virtue signaling, it's not necessary, and quit apologizing when you haven't done anything wrong. Absolutely.
If you apologize when you're in the eye of one of these Twitter storms in the hope that will make the mob disperse, that's not a sensible approach. What happened in my case when I was targeted for cancellation in January 2018, partly because I was one of the very, very few Conservatives appointed by the Conservative Party to a public body, in my case, the Office for Students. When I was targeted for cancellation, I apologised, hoping it would make the mob disperse. There was literally a mob of journalists on my doorstep, and my children couldn't go to school, and that was like throwing a piece of raw meat to a shoal of piranha fish. Once they smelt blood in the water, they just went completely nuts, frenzied, and I ended up having to step down from 5 different positions. So I was well and truly cancelled, and the effect of apologising was to accelerate the feeding frenzy, not to make the piranha fish go away. I think what can we do? I think, well, one suggestion that's been made is that instead of trying to repeal the Equality Act, or instead of trying to reduce the number of protected characteristics, to instead go with the grain and just argue that more and more characteristics should become protected. And if we can get enough characteristics protected, then it'll be as if no characteristics are protected, because everyone will be kind of bristling with protected characteristics. So the current inequality within the law, whereby if you happen to belong to one of these underprivileged quote-unquote groups, you have better protection than if you don't, that will be eliminated just by massively increasing the number of protected characteristics. So that's one possible strategy. But I hope that pressure can be brought on this government, and if not this government, the next government, assuming it's a Conservative government, to at least have a consultation about reforming the Equality Act, and then we'll need to organise and bring pressure to bear via that consultation to try and rein in some of the ways in which it's been used to police and suppress free speech.
Thanks, Toby. I think it was really interesting to hear from the audience as well, just from their different personal backgrounds. So that just shows how our own individual areas of work and expertise bring a specific critique of the Equality Act and equality legislation and the whole culture that we're dealing with, and give interesting angles on it from different perspectives. So my suggestion would be that people go to the Policy Exchange website and look for Paul Yowell's report. It's called The Future of Equality, Why It's Time to Review the Equality Act. It's a recent publication. It's a very good summary of things that are wrong and things that could be done, gives you a practical overview as a layperson, and then maybe with a view to contacting the FSU on the basis of your own experience with practical suggestions of how we might move forward as a movement, as a collective movement, to think about strategic ways to undermine or to challenge some of the more repressive elements of this legislation and its legacy, its cultural legacy. So that's a practical suggestion from me. But I do recommend the Paul Yowell report. It's an easy read, and it's a very good summary of the main issues. And on that note, I think it's over to Jan to close the event formally. Thank you for organising it, and thanks again for inviting me and for this really interesting panel and wonderful audience to workshop a complex issue in a very short space of time. So thank you very much.
Thanks ever so much, Anna, and to everybody else who's joined us, and especially the panelists. It's just great when people put their time in this way. Really good to see so many people on camera and off camera joining us for the first event of the year. Big news is that our next event is on the 25th of January, where it's 2 weeks' time, and we're going to have Harry Miller talking to Toby about his experiences the last few years of really playing the role of free speech warrior in the most admirable way. So the invitation to that will go out next week. And I would really recommend that if you want to try and encourage your friends to join the FSU, now is a really good time to do it. So suggest that they come along to that event. If they join up very soon, then they will get that invitation to that event. And then they can come along with you. And that would be brilliant if we just keep on increasing the numbers of these events and then building up to in person as well. Thank you very much for coming, and good night. See you in 2 weeks.